It is my pleasure to warmly welcome all of you to our 2024 Annual Law Lecture entitled Doing Human Rights in a Time of Turbulence. In this room, I think we have not very good, so that's how I can calculate. But we have more people online. So I'm also saying thank you to those of you online watching the event. And in our audience today, here and online, we have different people, including former students, alumni, practitioners, within the school and outside the school. So a warm welcome from myself and also the entire Essex Law School and Human Rights Center to all of you. I will also first start by thanking the real important people who have made this event possible. Amy Carty in our events team, Jenny and the rest of the professional services, and also my colleague, one of the deputy deans in the school, and one of my graduates. They've worked hard over time to make this event possible. I also would like to thank the Suffolk and North Essex Law Society for the sponsorship and collaboration over the years. It is quite an enduring relationship we've had, and we hope to continue. The Suffolk and North Essex Law Society represents solicitors throughout the region. And we are proud of the collaboration. We are proud of the relationship we have with SNELS. Because one, building and maintaining strong relationships with the professional community remains a key strategy of Essex Law School. And we know that by working with local practitioners on a range of initiatives, including via our law clinics, the Essex Law Clinic, the Business Law Clinic, the Human Rights Clinic, we're able to provide our students with practical opportunities to enhance their learning experiences and their employability. We are proud to describe ourselves as champions of experiential learning. And not just on the education side, we believe so much in impactful research. If you have had encounters with the school or with any members of the school and the Human Rights Center, you will also know that we have a global reputation. And just to give you some of the examples, we are ranked 49th in the world and 9th in the UK of all the law schools in the Times Higher Education World University Rankings 2024. And we were ranked 3rd in research power in the 2021 Research Excellence Framework conducted by the UK government for all the universities and departments over 7 years or so. So those are some of the, and we've been able to achieve that because of the impactful research carried out by staff of Essex Law School and the Human Rights Center. If you have also had some interactions with us, you also agree with me that we are an inclusive, welcoming, and international community of scholars and also practitioners within the Essex Law School and the Human Rights Center. And we hope you will be part of our community if you are not already one of us. And going back to the theme of today's lecture, we are honored to have our guest speaker, guest lecturer, Emeritus Professor Françoise Hampson. I'm going to talk a little bit about Françoise in a moment, but Françoise epitomizes what Essex Law School is in terms of excellence in research, impactful service, education-wise and research-wise. So we're proud to have Françoise in our midst today. And finally, I will go back to thank SNELS, Suffolk and North Essex Law Society, for one specific reason, which is the prizes SNELS have been awarding to our students over the years, and we hope we have many more years to go with the prizes. SNELS is represented heavily today by the president, who is here with us, as well as several other members in the audience here, as well as online. So thank you, SNELS. And talking about prizes, two of the prizes awarded by SNELS for this year. The first one was awarded to Anastasia Grady, who won the prize for the best overall performance by a second-year LLB student. Anastasia is currently on her placement year, so she's not here with us. The second awardee of the prize is Susanna Bochak, who is here with us. Susanna won the prize as the best graduating student from the LLM. Susanna? I'll hand over to the president of the Suffolk and North Essex Law Society. Good afternoon.
And welcome everybody. We'll now call solutions with SNELS for short, so it keeps it nice and straightforward. It's an honour to be here this afternoon as the president. I have been coming to these for quite a few years now as part of the council for SNELS, so it's a real honour to be here to present an award as well. Just really want to reiterate what has been said, and the fact that we've worked closely with Essex Law School for many years now, and that's grown over the years, and it's a wonderful connection to have. And us too, I believe, would like that to continue for the future, as much as possible, to give support, especially we were talking about the differences with the way into law now, and how that is a bit of a shrinking thing. So working with young students and people, bringing them in, and also working with law clinics, Essex law clinics, to help give those that are in learning law. It's not just about learning the law, but obviously it's about dealing with your clients, building the confidence to talk to your client, so that your client has confidence in you as well. And you can only do that through practice, getting into clinic, every situation is the same. So that's a great collaboration as well moving forward, just to sort of work holistically. So it's just I'll keep it short because I'm really looking forward to listening to Françoise talk about human rights. There was a lecturer a few years ago that really inspired by it. Thank you, everybody. Thank you for coming.
Okay, thank you. was talking about Essex Law School and the Human Rights Center. I mentioned Françoise. I wasn't here when Françoise was in the school, but from my first day, from my first day of arrival, I started hearing about Françoise and the rest of the people who established the foundation, nurtured Essex Law School and the Human Rights Center to what it is now as a global renowned institution. And I'm also very much aware that when we talk about the Essex Law School culture, the involvement of Françoise and the others before my time, before the time of Emeritus, in establishing that culture of a warm, supportive environment for colleagues, for students. Years down the line, colleagues still talk about Françoise's mentorship of students, of colleagues. Some of the colleagues I have in the school, actually former students of Essex Law School and Human Rights Center, and they still speak only Françoise. So Françoise is a world-renowned global expert in both international human rights law and the law of armed conflict. With many other colleagues, several other colleagues, Françoise built the reputation of Essex for human rights and the law of armed conflict, and has inspired and mentored countless students and colleagues in their work in these areas. I can attest to it. I wasn't there at the time, but I still see the impact with us. The influence and significance of Françoise's work and expertise is very clearly evidenced by the fact that this lecture is product. A few people wanted to register to be in this room. We have to say sorry, we've reached a good capacity. Many others joined us online to register. So it's not just joining, they registered to be with us. Well over 100 participants have joined online. Françoise is an Emeritus Professor of Essex Law School and Human Rights Center, University of Essex. She has taught at the International Institute of Humanitarian Law and in her colleges. She was on the steering committee and group of experts for the International Committee of Red Cross Customary Law Study. She has frequently litigated cases before the European Commission and the Court of Human Rights, including a large number of cases against Turkey in the 1990s. For that work, Françoise was named the Human Rights Lawyer of the Year in 1998. Together with her colleague, the late Professor Kevin Boyle. More recently, Françoise has submitted third-party interventions on the relationship between international human rights law and the law of armed conflict with our colleague, Professor Noah Luther, in the cases of Hassan and UK and Georgia and Russia, #2, and also with a former colleague of ours in the Essex Law School, Dr. Dara Moore, in Hainan and Germany. From 1998 to 2007, Françoise was a member of the UN Subcommission on the Promotion and Protection of Human Rights. From 2016 to 2021, Françoise was a commissioner on the UN Commission of Inquiry on Burundi. Françoise, thank you.
Thank you very much for that introduction. I'd first like to start by explaining the title doing. By that, I include, but I'm not limiting it to litigating. Human rights, that's human rights and not human rights law, so it includes human rights law, but it's wider than that. And by human rights, I mean the relationship between those exercising power and those subject to its exercise. It's about enabling the flourishing of the individual in community. Human rights law is not an individualistic charter, whatever some of the critics seem to think. Now, why time of turbulence? And in particular, why not crisis? This was that by crisis, it makes it look as if it's one specific problem. And I think what's remarkable about the current period is the range of different kinds of difficulties. First, we've got existential problems such as the climate crisis. Then we've got global political problems that are recurring in many different places, involving the threat of force, the response to unlawful resort to armed force, and the unlawful conduct of hostilities. And states respond to those. The third challenge is a challenge to the rule of law, or a rules-based international legal order. It's not that people are advocating different rules, it's that those challenging it are saying there should be no rules, that might is right. Then another range of crises is the economic crisis brought about by very high levels of state debt, which were in part attributable to what happened during the pandemic. Now, many of these elements are clearly connected. So, for example, climate change is absolutely inevitably going to mean massive disruption to migration. And the whole thing represents a challenge to the multilateral approach to international relations, which has been the key feature of how international relations have been handled since the 1940s. So the crisis in human rights isn't just the old problem of some states not taking human rights seriously or thinking that it matters. It's not even a problem where some fairly recent converts to the adoption of human rights standards have started backsliding, although there's plenty of that. But some states that were original sponsors of human rights and human rights law are themselves backsliding, and that's new. Over the past 8 years in this country, it's not just extreme right wingers who've expressed doubts about the UK remaining a part of the European Convention on Human Rights. It includes people regarded as sane and in the centre ground of the Conservative Party, such as Theresa May and Rishi Sunak, both of whom were actually prime ministers. So these are senior political figures, and they've contemplated withdrawal from the European Convention. I want to emphasise what this represents. This isn't just there's a treaty, we've been a party, now let's change being from being a party to not being a party. In the 1950s, the Council of Europe was the preeminent values-based intergovernmental organisation. In order to join, states had to promote democratic values, and it was opposed to political extremes of the left and right. Nowhere is this better seen than Article 17 of the European Convention on Human Rights. Can't use human rights to destroy the rights of others. In the early days of the European Convention, the UK did not accept individual petitions. Then it did so for 3-year periods. At first, renewal was a very real political issue across government. By 1978, when I was charged with the European Commission of Human Rights, the battle was between the Home Office and the rest of government. That's still probably the case, but it had shifted from being controversial across government to being basically a Home Office problem. And then it became a matter of routine, just accepted individual decisions, and it was not a controversial. So for them now to talk about withdrawing from that is really significant. It's a big deal, not only in Europe, but much more globally. I suspect that how you view the crisis may be significantly affected by your age. Those who are 65 and above will remember days when promoting human rights was very much an uphill struggle. It felt like 2 steps forward and 2 steps back. They're used to having to fight for anything to do with human rights. At the same time, it's possible that those in that age group may not take sufficiently seriously challenges such as environmental degradation and climate change, which have been an issue for those under 45 for the whole of their conscious lives. For the under 45s, which came to political maturity after 9/11, they're used to an environment in which they have to fight for human rights, but in which there was a so-called golden age, a bit like English history students going back to the 20s. So they've heard of this fabulous golden age, and they're aware of it, but they're used to fighting. The people most to be pitied, and that's probably the majority of this audience, are those between 45 and 65. As they came of age, barriers to human rights and international law generally, not just human rights, were coming down. It seemed as if you only had to push and doors were open. Everything seemed possible. Examples include one thing you may not have heard of, but which is a very remarkable treaty, the Chemical Weapons Convention. The Chemical Weapons Convention has the most intrusive and expensive monitoring system, which is necessary, but that you can imagine. Another example would be the International Criminal Court, undertaken 50 years of gestation, and yet it happened in the 1990s. Now, for those between 45 and 65, that's the world that they came into as they approached adult activity. So that generation is having to learn how to fight. But to fight effectively, you must be first clear what you're fighting about before you decide on how to do it. And that is what I'm talking about this afternoon, what we're fighting about. For reasons of time, I'll have to proceed by a bold assertion. We need to start by looking at what else was happening in Europe which made the reception of the European Convention possible and even desirable. How a state treats those subject to the exercise of its power was seen as an important contribution to the rise of fascism and Nazism. It was the lack of rules on that in international law that was seen as contributing to that rise, and particularly the lack of international law norms on which other states could rely. This link with the risk of conflict is famously finding expression in the preamble to the Universal Declaration of Human Rights, whereas it is essential, if man is not to be compelled to have recourse as a last resort, sometimes it is as a first resort, as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Not just a refuge for human rights, it's human rights protected by the rule of law. So what developments were happening that allowed human rights law to come to the forefront and to flourish? At the international level, interstate conflict is usually generated not by those seeking to avoid tyranny, but by those in power. But it's often different in the case of internal armed conflict. New political leaders may emerge before an outbreak of fighting, but it's often a bottom-up business with increasing disruption out of which warlords emerge. Straight away, this takes us to the domestic level. International law is not well placed to impose itself on recalcitrant national systems, but it is well placed to establish standards by which the member states agree to abide. The Council of Europe is one of the first regional international organizations to emerge from the war, and it's an example of that. There is nothing supranational about the European Convention on Human Rights or about the Council of Europe. It's a classic intergovernmental organization. So what was going on at the national level and what was happening where? Because different things were going on in different democratic European states. But what was going on was of the same type. For example, in some places, women got the right to vote for the first time after the Second World War. In others, the franchise was extended to cover all women over the age of 21. In some places, that took longer than others, and some a remarkably long time, like the France. In the UK, it's worth noting that it was not the European Convention and litigation, but private members' bills that abolished the death penalty, removed criminal sanctions from homosexual acts for those under 21, produced a qualified right to abortion, and liberalised divorce. That's not human rights law, that was domestic activism. Administrative law was absolutely transformed. To try and explain this, the extent of the transformation to you, when I was a law student, you only did a course on constitutional law that absorbed within it administrative law. You didn't have public law 1 and public law 2. It took up around 3 lectures during the whole year of lectures on constitutional law. And that was about the right amount of time. It dealt largely with procedural issues. It was very difficult to get substantive review of decisions that had been made. The concept of proportionality was alien to English jurisprudence. So that is an extraordinary change that has happened in administrative law, and those changes have made a difference to accountability in the rule of law. Political accountability has always been difficult in our parliamentary system because of how the executive controls the legislature, but there was only the chance of removing a government at periodic intervals, and that's a sledgehammer to crack a nut if what you're trying to change is one decision. So the availability of judicial review to challenge administrative decisions was really important. But above all, the post-war period saw the creation of the NHS, the passage of the Education Act 1944, of which I was a beneficiary, more comprehensive social welfare provision, and massive public and social housing provision. Legal aid was also made much more widely available. When people are looking at the context in which human rights law was developed, there's a tendency to focus just on the traditional civil liberties element. These economic and social aspects of the context are at least as important as the civil liberties. This social settlement is the support of all the major political parties. When Macmillan took over as Prime Minister in the 1950s, he did not try to go back to the status quo ante. There was a commitment to build a better society, one based on democratic values and reducing inequality. And this was seen as a counter to the Cold War and the nuclear threat. This wasn't something that just required a little legislation here and there. It was not just a destination, it was a way of proceeding. It was a route. It was how you chose to go about things. And there were similar developments in other European democracies. What they particularly had to focus on varied because they've got different challenges, but they were all on that same journey. Now, I would suggest that those developments that I've talked about that made it possible for human rights law to fit in could be characterized as good governance, rule of law, accountability, and equality. If you can see that sufficiently clearly. I'm calling them the buttresses of human rights. I'm not suggesting that there aren't any others. We'll see later on how I'm defining buttress, which might limit some of the things. There's a lot of overlap within individual buttresses and between the buttresses. But let me unpack something about the buttresses of human rights, and that should actually be good governance rather than good governance. Good governance, by that I'm including issues like participation. Who can vote? Who does vote in practice? Issue of turnout. The electoral system, the determining of constituency boundaries, the whole question of leadership, and that leadership, they need to listen, but then they also need not just to try and find out what the people say they want and to promise them that they will deliver it and then fail to do so. There has been remarkably little leadership for the past 60 years. They've constantly been looking at what people said they wanted and trying to deliver it or claim they were. It also, good governance involves the devolution of executive power to the right level, because your chance of influencing things that affect you depend on what's being decided where. There's a need for openness in policy development as well as policy implementation. Freedom of information is part of good governance, as is transparency and the separation of powers. There's a need to look at the respective role of individual MPs and political parties. A need to look at lobbying and in particular the financing of lobbying. Now, I'm not saying what any of the answers are to these issues. For example, the voting system, you can come up with very good democratic reasons why it should be first past the post or why it should be PR. But the point is, these are issues that need to be addressed as part of good governance. What has happened to good governance in the past 60 years? Well, one of the most marked things is the decline in trust and trustworthiness. I think the distinction made by Laura O'Neill over trustworthiness is an important one. All you need to do in that regard is look at the levels of turnout. And anyone who's been listening to some of the broadcasts from different constituencies will see the skepticism that is being expressed about whether there's any point in voting. There's also been a rise of the career politician. When I was young, a significant cohort in each political party consisted of people who had a career till their 40s and 50s, and then as an act of public service, chose to stand for Parliament. Those people weren't particularly after ministerial office, had nothing to lose, they were doing it as a form of service, and they were more independent from their political parties. You've seen dramatic centralisation. I mean, we've always felt centralised, but it has become even more marked. And there's less and less of a role for local government. In the 70s and 80s, they did have meaningful decision-making power and the ability to spend discretionary sums and to promote different policies of their choosing. That has now gone. They're simply the implementers with not enough resources to implement nationally binding decisions that have been taken by the central government. We're one of the most, if not the most, centralised government systems in Europe. And that is part of why people feel they can't actually take decisions that impact them, because there's no effective local government. There's an age-old problem in this country of a separation of powers because of the extent of the executive's control over the legislature. Here you can hear the constitutional lawyer speaking. Up to 90 or so of MPs are on the government payroll, whether as junior ministers or as parliamentary private secretaries. That means there's a lack of independence in the legislature from the executive. There's a lack of transparency, particularly with regard to policy formation. All these things have led to people feeling they're not being listened to, that they can't change anything, that there's no point in voting. And they think that all the main parties say, because their experience of government has been distant from them and not responsive to them. So they think they might as well try something different, and that means extremes. Not because they're necessarily in favour of those policies, but just as a wake-up call to government and as something, trying something different. That one may learn the hard way. That's what happens if you put people in a position you just put people in France. In this country, Brexit is a classic example of people thinking, first of all, assuming that things don't really go the way it did, but then wanting to punish Westminster. But they ended up taking a decision on leaving the EU about issues that have nothing to do with the EU. It leads to a rise of populists who are promising easy solutions, when in fact the solutions that need to be found aren't easy. So it's going to lead to exactly the same frustration if they ever assume power. It's paving the way for assumption of power, at least in some states, by autocrats and dictators. There seems to be more of an aversion to that in this country than in certain other places, but there's reasonable likelihood that reform will be parliamentary representatives, but not many as a result of the next election. There's a preference when everything looks too complicated to have what is decided by the strong man. The strong man will come and decide everything, so you don't have the responsibility. There's a lack of engagement. If nobody's listening to you, why not just act like a baby and let them take all the decisions? That makes it much more difficult for Western European societies who are going through these kinds of processes to make comments about autocrats and dictators in other jurisdictions. So there's clearly a crisis in good governance in many European states. It's not about the issue of power changing whoever is in power or the exercise of the vote to change that. It's a problem with what they're doing when they're in power. The second buttress, rule of law. Over the past 70 years, first we saw significant progress. There was the widening of the scope of particularly civil legal aid. There was the reform of judicial review. More recently, judges have acquired a certain measure of bravery. For example, the rules on jurisdiction in corporate responsibility cases all that's to be encouraged. And there was an important change in the civil service group. Now, about 30 years ago, they were told they not only had to respect domestic law, but they also had to respect international law. This gave a lot of power to civil servants if a minister was proposing to do something that would break international law. The government, not surprisingly, is rowing back on that. The Human Rights Act was an important development, but I'm glad that it did not happen until the courts were used to EU law and had a better understanding of how to use proportionality. I was really struck when I served in the subcommission on the promotion and protection of human rights from 1998 to 2007 by some of the conversations, surprising conversations, I had with diplomats off the record. At the start, so between 1998 and 2001, many diplomats from many different states raised the fact that European states seem to accept and implement judgments of the European Court of Human Rights, even if they disagree with them. I was first surprised that they actually knew about that. I was even more surprised by the impact it had on diplomats from states where they were poo-pooing the idea of human rights. They seemed to think that European states were walking the walk as well as talking the talk. They said, it's making us wonder whether human rights isn't just a political stick to beat us with, but has actually something to do with governance and rule of law, and maybe we ought to be paying attention to it. I had not expected that beginning of openness. More recently, the rule of law and the idea of rules-based international legal order has taken a knocking. There is first the question of resources. Different parties have cut back the scope and value of legal aid, particularly civil legal aid. The funding of the judicial infrastructure has been appalling, leading to terrible delays. The rule of law does not come cheap, whatever government ministers might think, and this is across political parties. The strike amongst criminal legal aid barristers was really striking in that regard. Then there is the going back, both with regard to domestic law and international law. At the domestic level, there's been an attempt to restrict the scope of judicial review. The government at the time, just say it was Boris Johnson's, set up the independent review of administrative law and tried to get an independent panel to say that administrative law wasn't working, the courts were exceeding their appropriate jurisdiction. That didn't work, so they've had to try and find other ways, like, for example, looking at the rules on standing to see if they can limit the scope of judicial review. At the international level, it's a truism to say that no one wants to negotiate any treaties in areas such as human rights or the law of armed conflict. They're frightened we could go backwards and that people would reject things that have been in treaties for 50 years. It's not just mavericks such as Trump who prevented the WTO Republic from working by blocking judicial appointments. Allegedly respectable leaders all over the social Western have frustrated the operation of refugees. Many have increasingly ignored the judgments of the European Court of Human Rights. In the UK, the Brexit negotiations were a real test of commitment to the rule of law internationally. The contribution to international jurisprudence of Boris Johnson's government was the suggestion that because they wanted, I quote, to break international law in a very specific and limited way, that was all right. I would suggest that the turning point was not 9/11, but the reaction of European states to US behavior after 9/11. European states turned a blind eye to the US committing torture. They allowed their territories to be used for black sites where the torture occurred. They allowed planes to land in their airports, transiting people who were being transferred to other places where they would be tortured. I saw the impact in the subcommission. Those people who had previously said, it looks as if they've been this up. This might be important. said, oh, it turns out it's politics and the Western states didn't really mean it. They're not really interested in human rights or the rule of law. That was just politics. It's done so much damage to the reputation of the United Kingdom and its history, the apparent going back on things that were seen as not. But there is one ember in the dying fire, and this ember could be fanned into life. A bit of positive news that's recent. When the latest Rwanda bill was going through the House of Lords, some dissident conservative peers who opposed it did so not in the name of human rights. They weren't interested in the individuals who might be affected. They did it in the name of the rule of law and the reputation of the United Kingdom for adhering to the rule of law and our international commitments. That's something we can work with. The third is accountability. There's a big overlap with the rule of law and accountability, but it's much wider because it includes political accountability as well as legal accountability. Our constitutional system relies on conventions, which, while not technically law, are supposed to be morally and politically binding. Well, that's the part. The last political resignation, not attributable to personal wrongdoing, but ministerial responsibility for a decision, is, I think, that of Lord Carrington in 1982 over the invasion of the Falklands Islands. In the old days, there was a considerable level of hypocrisy. It reminds me of the maxim of La Rochefoucauld: l'hypocrisie est l'hommage rendu à la vertu par le vice. Hypocrisy is the tribute rendered to virtue by vice. It's very, very useful if you're a human rights campaigner. I found this on the Commission of Inquiry on Burundi. If there's a mismatch between how a state or an individual wishes to appear and what they're in fact doing, you can use it. They fear the publicity because of their self-image, and that can lead them, when you point it out to them, to behaving better. But that only works if they accept that what they're doing is wrong. So if there's something to be ashamed about. With Boris Johnson, there was no cover-up because he was shameless. He seemed to think that the rules did not apply to him. So part of the problem with political accountability is the relationship between the executive and the legislature in our system, and between individual MPs and political parties. The developments in select committees over the past 40 years or so have helped a bit, but not really with regard to accountability. They've helped with regard to policy and what they're doing, rather than who's responsible for bad decisions. Big public inquiries help, as we're seeing a bit at the moment with the Post Office, but they cost a fortune and take forever. On legal accountability more generally, is the earlier discussion on the rule of law, but again, this recent highlights include the attempt to restrict the scope of judicial review and restrict standing and the threatened withdrawal from the CHR. What about the fourth buttress, equality? By equality, I mean two quite different things. First is the issue of discrimination on various grounds, such as race, sex, and disability. Second, there are attempts to mitigate inequality by means of access to education, healthcare, and a benefit system that allows them to participate actively in society. The first of those, that's to say discrimination, has made significant progress, but is not good at addressing systematic discrimination within institutions. The second, that's all the giving access to an ability to participate in society, is a disaster area, especially in the US and the UK. Virtually all Western European societies are showing increasing levels of inequality. In the UK, that rate is increasing faster than elsewhere. And that's the result of specific decisions taken with regard to welfare policy and their implementation, things like the two-child cap, for example. In other words, the situation could be different if we'd adopted different policies. There's nothing intrinsic about it. For example, I believe that in Denmark, if you're made redundant, you are generously supported for a short period of time. That means you can afford to pay for retraining courses, you can afford to pay for the travel to go on a retraining course, and then you get another job. Here, people are badly supported, so they can't afford to pay for the retraining or even the transport to the retraining place that would enable them. One of the roles of the public system of education and of health is to create a more level playing field. The underinvestment in these areas is preventing them from fulfilling that role. In the past, the talk was of shirkers and scroungers, but recent public opinion polls suggest that the public is getting a more sophisticated understanding and that they recognise that generally that is not a big problem. What is a real scandal is the number of working families where children are being brought up in poverty in the 6th wealthiest country on the planet. And these issues are not inevitable, they're the result of choices that have been made. What is also striking is the lack of discussion of this in terms of values. When you're looking at the question of a level playing field, a level economic playing field, we don't hear talk of what kind of society do we want to create. And I'm a bit puzzled as to why you don't hear any talk in those terms. It's always about the impact of particular changes and who will it affect. It's not about the wider issue of what kind of society are we creating. Each of these 4 buttresses has an element that relates to human rights, but they're also much wider than human rights. So part of good governance is to do with human rights, but part isn't. Part of the rule of law is human rights, but some of it is much wider. So where does human rights fit in for the buttresses? Well, there are 2 possibilities. I do understand the difference between causation and correlation. I have no training in social science methodologies, but I believe that some of those listening in do have such training, so please research projects on this. I don't know how to establish whether what we're talking about is buttresses that are necessary for a realization of human rights or simply supportive. This matters because if they're necessary to creating a space in which human rights can flourish, then you've got to address the challenges in these buttress areas as well, non-negotiable. Otherwise, it's just going to be ineffective. If they're merely supportive, then it would still make sense to actually use the challenges in these other areas to try and also support human rights. But what buttresses and human rights have in common is they're all based on advantages. You can't have authoritarian good government. You can't have arbitrary rule of law. When did you last hear a defense of democratic values? I can't remember when I did. When did you hear someone explaining why the rule of law is really important and matters not only for the weak and vulnerable, but also for the powerful? It means they don't have to fight for everything, that some things they can just claim. Here of the society we're trying to build and being one community, respecting difference, but seeking the fulfillment of all. It's certainly not in the manifestos and the principal political parties. Where is the leadership on these issues? Where is the big picture? We're not getting it from anyone apart from in occasional speeches by Gordon Brown on the issue of poverty. In this environment, human rights law is a very easy whipping boy. You get the critics of human rights saying it's just there for illegal migrants, for criminals, magically forgetting all the issues where the critics in the Daily Mail actually approve of some of the decisions that are made. This is not the time to make human rights specific arguments. If the buttresses are necessary to human rights, a human rights specific campaign would be ineffective because the buttresses need bolstering, they're all in crisis. If the buttresses are merely useful, then it would be useful to actually work on them with others, so it takes some of the pressure off specifically the human rights cause. I think there should be no attempt to bring cases which would expand the scope of existing jurisprudence of human rights courts, but cases should still be brought to reinforce existing jurisprudence and possibly in new context where the principle is the same, but you're applying it in a new context, that's fine, but don't try and extend the principles at the moment. I think we first But before looking at how to set about campaigning, I want to say a word about the context. I could put lots of other elements in the context, but I limited it. Now, the difference between the buttresses and the things in the context is that the buttresses all have values embedded in them. The context elements don't. They're facts or phenomena. How you address the facts or phenomena may well reflect your values, but the issues identified aren't intrinsically value. For reasons of time, I will only highlight one fact, and that's the technology. The implications of most of the others are, I think, very obvious, but I want to say a word about technology. It covers all sorts of things, but it includes in particular two. First, modern communication. It's possible, and many of our youngsters seem to do this, to live in a bubble. You only talk to people who agree with you, and you egg one another on to more and more extreme views. That is the exact opposite of what is needed to promote democratic values. You've got to learn how to live with people who think differently. We've got to relearn living in community, starting within the family, then in your neighborhood, then your town, then your region, and so on. That involves not just talking to people who are like-minded. It means also listening to others around you. It means learning to compromise, learning to negotiate. Not only do you have to acquire these skills, it takes time and it takes engagement. And those who give up because they think they're never going to be listened to, there's a risk they're going to be so disengaged they're not willing to put time in. Democratic values, human rights, the buttresses of human rights require engagement. The other issue under technology that needs to be flagged is artificial intelligence, which raises a number of separate and very real challenges. So what do I think is the way forward? We need both global and national campaigns to support democratic values. The buttresses are wider than human rights and human rights concerns. There's already a wide range of organizations campaigning on specific issues within this framework. For example, something like the Citizenship Foundation. It is not a case of replacing them. It's a case of getting them to work together. Now that sounds like an absolute nightmare. Trying to coordinate probably hundreds of organizations working on different issues in their own different ways. But believe it or not, there's a precedent, a slightly odd precedent, but one that had to cope with this challenge. And that's the global campaign to ban anti-personnel mines in the 1990s. I got a very close-up view of that. I was involved with both the international and the national level. It was a horrendous challenge because they wanted to find all sorts of ways of building concerted pressure to get a ban on landmines at the time when they were only negotiating greater restrictions on use. The first difficulty was creating an international coordinating committee that had some representatives from international NGOs, and some national campaigns were represented on it. So it was always representing others. There was no individuals on the international. At the national level, you had to cope with an extraordinary range of things. And this was a steep learning curve for those involved in putting it together. It turned out, in some countries, you can't be a charity unless you accept government money. You don't have to accept money. In other places, accepting government money meant you couldn't be a charity. In the UK, a big issue was Oxfam had got limits on how it could campaign because it was charity. You couldn't do political campaigns. A campaign against the arms trade was only used to political campaigns. They found a way in which they could enable these very, very difficult groups to come together. There needed to be clarity and coherence in what they were pursuing, but they were given a large measure of flexibility in how they pursued it. Now, you might have thought that was a sign of weakness. My experience was it was actually turned out to be a strength. because each of these organisations reach different constituencies. So you reach to more than you do if you only had some of them. So it's doable, it's very, very difficult, and you've got to be willing to allow a large measure of flexibility in what they campaign about and how they campaign. But it is possible to do it on condition nobody does anything inconsistent with the message. So something along those lines might be a useful framework, both at the national and at the international level, for promoting water. But how do you set about doing it? That's the framework, but what about the means for doing it? When specific proposals are being considered, I think it's vital to get the endorsement of the public. Remember, one of the big problems with the rule of law is people thinking that things are done to them, they have no say over what's being done, and that they're just at the receiving end of government. It cannot be a top-down initiative. There's been too much of that. But at the same time, you're going to have some people steering it. You're going to have to consider what people want when they think of the trade-offs. If you want a bit more of that, it's going to need a bit less of that, and so on. Now, there is here again an interesting precedent. It's the citizens' assemblies that were used in Ireland, they were used in the run-up to and before referenda on abortion and on equal marriage. Now, in Ireland, those issues were very, very divisive. It's not that they were using them for easy issues, far from it. And by some miracle, these things really worked. 100 people were identified, and they were made sure there was a balance of age, sex, and background, etc., and levels of education. It was a very carefully organized system where there was one person presiding. They had expert witnesses and experts they would call on. They met for 5 weekends. They would gather on the Friday evening, and they would meet on the Saturday and Sunday morning, and they would discuss what the present situation was, what the proposals were, what the implications were. They could have access to anyone with the extreme views, either wanting abortion on demand or a complete ban on abortion. They spoke to everybody, and they reached a consensus. A slightly surprising consensus coming from Ireland with the abortion law, but they did reach a consensus when they felt a sense of responsibility. It's a bit like, in some ways, a bit like jury trials. I've sat on the jury once. Absolutely horrible, but the business of everybody taking it seriously, what they were doing, was really striking. And this seems to have happened with these citizens' assemblies. Now, it might need to be tweaked a bit because this is a different kind of issue, but some means by which you could have a range of different citizens' assemblies on different issues that arose when you're trying to thrash out what changes are needed in order to develop a view that's based on the kind of society we're trying to create. There would be a useful role for some international statesmen as symbolic leaders, as well as executive leaders. I have in mind people like Obama, Mary Robinson, and possibly even Gordon Brown. I think in the most legal areas should not be left to the lawyers, because that would look like special pleading. But of course, lawyers are very well placed in all these areas to help with arguments and examples. So it's not just human rights that are in crisis, but all the buttresses that have supported human rights are in crisis in different ways. And that obviously also includes human rights. No one can do everything, but everyone can do something. What, as a good citizen, are you going to do?